So thank you so much again, everyone, for joining us. We're thrilled that so many of you could join us today for the Know Your Rights. What happens when one parent wants to move away with their child or relocation webinar. If you're someone who's going through family court issues right now and you're seeking guidance and information, welcome. We're so glad that you're here. If you're a service provider or an advocate, or if you're just interested in learning about family law, we welcome you as well. So first, we'll do some quick introductions. My name is Molly Burke. I'm the Associate Director of Advocacy, Policy, and Community Engagement at Family Legal Care, and I am also one of our staff attorneys. Joel?
Hi, good afternoon. My name is Joel Banuelos. I am a bilingual staff attorney with Family Legal Care. And thank you everyone so much for joining us.
Thank you. And Ebony?
Hi, good afternoon, everyone. I'm Ebony Morell. I'm the Community Engagement Manager here at Family Legal Care. Thank you all so much for taking the time to be with us today.
Thank you. All right, and before we get to the presentation, you may have heard or noticed that we have a new name. LIFT is now Family Legal Care. All of our programs and services, which we're going to go over today, have remained the same, but we're really excited because we think that our new name, Family Legal Care, better conveys who we are and what we do and the heart of our mission, which is to provide compassionate support and care to families going through New York State Family Court and ultimately to help increase access to justice. We hope that you all are as excited about our new name as we are. And just a couple of housekeeping items before we get started. We really want this webinar to be interactive, so here are some ideas of how you can participate. If you haven't already done so, please say hello, introduce yourself in the chat, and throughout the presentation, we'll be asking a series of poll questions. Please participate. We'd love to hear from you. We'll be stopping periodically. We'll actually be saving time for questions at the very end, so you can submit any questions that you have to the Q&A box at the bottom that you see. And then finally, feel free to send us a chat if you have any comments or concerns that come up during the webinar. So now to our first poll. What brings you here today? Please take a moment and select the option that represents you best. I am a parent or caregiver. I am a partner or advocate looking to help my clients. I am interested in learning about family law or something else. We'll give you all just a minute to answer that. All right, and if we can have the results. Awesome, we have a great mix of people here today. So, here is what we are going to cover today. I'm going to talk first about Family Legal Care's services and programs, including how to reach us if you or your clients need any support. And then I'll give a really brief overview of family court before I turn the presentation over to Joel. And Joel's going to be covering most of our substantive law topics today, including custody and parentage, as well as moving away with your child, or what's known as relocation. And then Joel will turn it back over to me to talk about jurisdiction and where to file, and we will then save time for questions at the end, like I mentioned before. Now, as we're discussing these topics, I just want to note that all of the material that's covered here today is intended to be legal information only and not advice. As I mentioned earlier, we encourage you to submit your questions using that Q&A feature below, but you may hear us tell you to contact our helpline or to speak to an attorney for more specific legal advice, and that's because every situation is different and what applies to one person may not apply to everyone. So if you're not familiar with Family Legal Care, we were started in 1996 when a group of 3 young lawyers recognized the need for people to get accessible legal information, and they set up a card table in the Manhattan Family Court to answer questions, offer guidance to anyone who needed help. Over 25 years later, family legal care has really grown, but our mission remains the same, to increase access to justice for families in the New York family court system. Today, we're doing this by offering parents and caregivers free legal information and advice, resources, and technology to help them navigate that family court system. And we do this by providing these services across all 5 boroughs of New York City, as well as throughout New York State, and even outside of New York State, so long as someone has a case or an issue within New York Family Court. So, generally, the first point of contact for anyone who needs help from us is through our helpline, and they can access through phone, live chat, or email through our website. And once you contact our helpline, you'll connect with one of our helpline associates who can give you general legal information about New York family law and family court procedures. While our program associates are not lawyers, they are incredibly knowledgeable, and many people find that their question may be answered and that they have the information and the resources that they need after speaking with our helpline associates. Now, if someone needs more help, if they need some legal advice, our helpline associates can also screen and determine if a person is eligible for a free consultation with one of our staff attorneys. And if they're interested, schedule the appointment right then and there. Our general hours on our helpline are Monday through Thursday from 9 a.m. to 1 p.m. and 2 p.m. to 5 p.m., and Fridays from 9 a.m. to 1 p.m. and 2 p.m. to 4 p.m. The phone number to reach our helpline is right here on our slide, but it's 212-343-1122. And like I mentioned, you can also live chat them or email them through our website, familylegalcare.org/helpline. So if our helpline determines that you are eligible for a free legal consultation, you will speak to one of our staff attorneys or outside pro bono or free volunteer attorneys that will provide limited scope representation. Limited scope representation means that you'll meet for a 1 hour consultation by phone or video, as well as a possibility for follow-up consultations. And the level and amount of support provided depends on your case and on your needs. Limited scope representation really means that we can provide legal guidance and legal advice, but we don't go into court with you. Now, some examples of what our attorneys can do include helping you prepare for court and file petitions or motions, explaining legal concepts and legal standards, and providing that legal guidance and advice and telling you what your available options are. So let's talk a little bit about how you can qualify for our services. We have no income requirement for any of our services. The only requirements that we have are that you are not already represented by an attorney, the case is in New York Family Court, and that the type of case is one listed on this slide: paternity and parentage, child support, custody, visitation, and some guardianship cases. And then orders of protection, domestic violence, we don't provide advice on those. However, we can provide advice on how an order of protection may impact one of the other types of cases listed here. Now let's talk about some of our additional resources. We have legal resource guides, or LRGs, and I refer to them as cheat sheets to family court. We have 60 original guides that are written summaries on many New York family law topics that are available in 9 different languages, and you can find them in all of the New York City courthouses through partners, as well as on our website, familylegalcare.org/guide. Family Legal Care also recently launched a digital justice initiative to address gaps in the family court's online resources. And one of the resources that came out of that
Molly,
is,
Molly,
oh,
I'm sorry. Could you just
yes,
slow down just a little bit? I'm sorry.
absolutely, not a problem. Um, One of the resources that came out of that digital justice initiative is our tech hub. And at our tech hubs, litigants can access technology and receive assistance to attend virtual family court hearings, download and submit family court forms, as well as navigate the online court system. And people can also get legal information right at our tech hubs like they can on our helpline. And to make an appointment, they can email techhub@familylegalcare.org or call 646 496 0046. We also have what we call a family law navigator tool, and this is an automated tool on our website that can answer questions about your particular family law situation, and it can generate a more detailed, customized report with information about that situation, some links to forms and petitions that you may need. And you can do this by answering just 3 to 12 simple questions to get that tailored report that's specific to your family law issue. You can find it also on our website, familylegalcare.org/navigator. And lastly, speaking of forms, on our website, we also have links to common court forms, including our guided court forms. This is a free program that walks you through completing certain family court forms. At the end, the program will generate a completed document in PDF or Word format that is ready to be filed with the family court. Our guided court forms and Family Law Navigator are really great tools designed to simplify the court process, so we encourage you to check them out. So now let's talk a little bit about the family court and pro se litigants or unrepresented litigants. In New York, family court hears and decides certain types of cases, such as the ones that you see listed here. The ones in green are the types of cases that family legal care attorneys can advise on. And remember that in New York, divorce cases are not handled in family court. They're actually handled in a separate court called Supreme Court. And then finally, you should also know that every county in New York has its own family court, which means that there's one per borough in New York City. And family court in the state of New York is intended to be a pro se court. Pro se means unrepresented by an attorney. This means that the family court is intended to be more friendly and accessible for people who do not have an attorney. There are no filing fees, and rules are supposed to be a little bit more simple. And in fact, most people do end up going through the family court without a lawyer to represent them. If you're dealing with a family court case, you may be able to get a lawyer assigned to you at no cost, but this depends on the type of case and on your income. We're going to cover a little bit more of that today, but if you have any questions, please feel free to reach out. And please know that you do not need a lawyer to start a case in family court. You have the right to file petitions and start cases on your own, but this is also where family legal care can help. So now I am going to turn it over to Joel to talk a little bit about custody and parentage.
Thanks so much, Molly. As Molly mentioned, I will first discuss the concepts of parentage, paternity, followed by a brief discussion of custody and visitation, and then I'll go into our main topic of today regarding what happens when a parent wants to move with a child to another location. Starting with paternity and parentage. And let's first define those terms. Next slide. So parentage is the status of being a legal parent, whereas paternity is the status of specifically being a legal father. Part of the reason that we have these two terms is that in the last few years, New York passed some laws, one of them being marriage equality and others that expanded what it means to be a legal parent and also how people can become parents. As a result of this expansion, the courts and the legal community will sometimes use the term parentage instead of the term paternity because it is inclusive of these new definitions. And so in today's discussion, I will use the more inclusive term parentage, but just be aware that both terms are sometimes still used in the courts. So why is parentage important? Parentage is important because once it is established, a parent is financially responsible for the support of the child, and a parent also has certain rights to parent the child as well as other responsibilities. Let's discuss how parentage is established. Except under certain circumstances, when a child is born, the birth mother is automatically the legal parent of that child. However, the parentage of another person, someone other than the birth mother, for example, the father, can be established in one of several ways, and I'll go over 3 of them today. One, as you can see here, is what's called the marital presumption. What this means is that a child that is born to a marriage is automatically deemed the legitimate child of both spouses, and the parentage of those spouses is automatically established. This presumption generally does not need to be proven in court. It can be proven simply by establishing that the parents were married when the child was born. Another way of establishing parentage, as you can see here, is with a document that's called an acknowledgement of parentage. This document is a standard form, and if it is signed by the birth parent and another person, then the parentage of that other person is established. Again, this document can be signed out of court, and it does not need to be done in court. Another way of establishing parentage is through what's called an order of filiation. As you can see here, the 3rd option, and this is a court order that declares that someone is the parent of a child. The court can enter this order if both parents consent, meaning that they agree, or if they don't consent, then the court will make the determination either through a DNA test or one of the other methods of establishing parentage, some of which we've talked about here today. In addition to these 3 methods, there are a couple of others that I will just briefly describe. They include, one of them is a concept called equitable estoppel. And this can be used, this concept, this doctrine can be used to prevent someone from denying that they are the parent of a child. And it most often occurs when a person maintains a parent-child-like relationship with a child for a certain length of time. And another method of establishing parentage applies when a child is born through reproductive technology, such as IVF or surrogacy. Parentage of a child that is born through this method can be established so long as the parents meet certain requirements in a statute that's called the Child Parent Security Act, or the CPSA. All right, next slide. Generally, the people who can file for parentage of a child include those that are listed here. So you can see here the biological parents. The Department of Social Services also can file, and this can happen if the birth mother or the custodial parent of a child, rather, receives certain types of public assistance. Then DSS, the Department of Social Services, can file for parentage on behalf of that custodial parent to determine who the other parent is and potentially pursue child support against that other parent. All right, next slide. One point we'd like to highlight is that once parentage is established, you have all the same rights and responsibilities as the other parent. Okay, turning to custody and visitation. Let's begin by defining what custody and visitation mean in the family court. And in general, custody refers to the rights of someone to parent a child and the rights and responsibilities that go along with that. Visitation is the right to have access to or to spend time with that child. And custody can be broken up into 2 categories of rights. One is called physical custody, and the other is called legal custody. Physical custody first. That refers to who the child lives with. Another term that can be used instead of physical custody is residential custody. And so in other words, it refers to the parent that the child lives with more than 50% of the time. And generally, the other parent, who the child does not live with most of the time, can have visitation, which again is that parent's right to have access time with the child. The other category of rights is called legal custody, and this refers to the right to make major decisions concerning the child. Major decisions include big decisions such as where the child will go to school, major medical decisions, and others. They don't include day-to-day decisions like when the child eats or when the child goes to bed, things like that. Generally, without a court order, parents have equal rights to the physical and legal custody of their children. However, if the parents cannot agree on how to divide these rights between them, they can go to the family court and ask the court to determine how to divide these rights by starting a custody case in the family court. All right, time for another poll on the next slide here. Until what age can a court determine the custody of or visitation with a child in New York? We'll give people some time to pick their answer. The options are 16, 18, 21, or none of the above. All right, do we have enough for the next? All right, so the answer is B, and most of you got that correct. In New York, courts can determine custody visitation until the child is 18. After 18, the court can no longer make these determinations for a child. Okay, next slide. Let's briefly discuss how a court determines how to divide these rights between parents. In deciding these issues, the court's most important consideration is what's called the best interests of the child. And what this means is that the court considers first and foremost what is best for the child, not what is best for either parent. The court can consider what is in the interests of the parents, but the paramount, the most important concern for the court is what is best for the child. And there are many factors that the court can consider when deciding what's in the best interests of the child. Some of those factors are listed here, but they can include many others, an unlimited amount of factors, as long as they are relevant to the circumstances of the family. There are several options for how custody can be divided, and they're listed right here. I'll just touch upon them very briefly. One of them is what's called joint custody, and this is where both parents share equally in making major decisions for the child or parenting time, or both. Another way to divide custody is to grant one parent what's called sole custody. And this is where one parent has more decision-making authority or more parenting time than the other parent. And then finally, the court can split decision-making between the parents in a way that one parent has more power over certain spheres of the child's life. In this scenario, the court splits the areas or the spheres, as it calls it, in which each parent gets to have more decision-making authority. And these areas can include education, medical, religion, and others. Okay, time for another poll. True or false? If you want to relocate with your child, you must have a court order. If we have enough answers, the answer is false. And most of you got that correct as well. As we will discuss in this next section, the answer is that you might need a court order, but the answer depends on the situation. So let's discuss this in more detail. And let's start first by defining the term relocation. Relocation typically refers to one parent wanting to move out of the state or to a location far enough, a location that is far enough away that the move could deprive the other parent of regular and meaningful access to the child. Basically, what this means is that it's a move that might interfere with the other parent's rights to see the child and to have a relationship with that child. Relocation typically does not include moving to somewhere that's very nearby. And so just a few examples to kind of illustrate this. If a parent were to move, say, from Harlem to a few blocks away on the Upper East Side, or from Queens to a nearby location in Brooklyn, those generally would not be considered relocation because they're so close by that those moves may not interfere with the other parent's access to the child. Okay, and then next slide. Not all relocations require going to court, as we just kind of highlighted. In general, in New York, if a parent wants to move with a child that's, again, far enough away that it could interfere with the other parent's rights to see the child, that parent typically needs one of two things. Either they can have the other parent's consent, meaning that the other parent gives permission to move, or if the parent that wants to move can't get the permission of the other parent, then it can ask for permission from the court. So you need one of those two things. And we put together a chart here to help explain this a little bit more. But again, just remember that these are general guidelines and every situation is going to be unique. So the custodial parent may need to go to court if there is a custody order that's already in place, but that custody order does not address relocation, or if the custody order that exists expressly says that the parent cannot move with the child, or if the other parent does not want the custodial parent to move, if the other parent says actually objects to the move, then you may need to go to court. On the flip side of this, the custodial parent, meaning the parent that the child lives with, may not need to go to court if the other parent consents or gives permission to the move, or if the custody order explicitly says it is okay to move, and there is an order already that says that, or if the other parent has, the other parent that is not looking to move, but has not been involved in the child's life. And in that case, you may not need the court's permission. So let's talk about how a court decides whether to allow a parent to relocate. And a court decides this based on the circumstances of each case. But they will also depend on whether there is already a custody order in place. If there is no custody order yet, the judge or a court must look at the situation as a whole and decide what custody arrangement would be in the child's best interests. So there's that term again, the child's best interests. And the court will look at several different factors, including some of those that we discussed before when we were talking about general custody and visitation. In addition to those factors, though, since a parent is looking to move, the court can also take into consideration whether the move would be best for the child, in the best interest of the child. If there is already an existing custody order, and that order either doesn't address relocation or disallows relocation, then the court's analysis is a little bit different, because the court in this scenario is deciding whether to modify the existing court order and to allow the custodial parent to move with the child. In that situation, that is when there is an existing court order that doesn't address relocation or expressly prohibits it, New York's approach in deciding whether to allow the relocation and to modify the order was established in the case that's called Tropea versus Tropea. You don't need to remember the name of the case, but we provided it here just in case you want to look it up. What it essentially says is that in deciding whether to allow a relocation and to modify that prior order, the court will look at, quote, the totality of the circumstances, end quote. And again, it will look at the best interests of the child. So there's that term again. In determining the totality of the circumstances and best interests of the child, the court will consider a list of factors that are known as the Tropea factors. And those factors are listed on the next slide. Here they are. It's important to mention that the last bullet point here is any other factor. As you can see here, any other factor that the court thinks is important and relevant. Because really a court and a judge can consider anything that is relevant to making this decision. As you can see from this list, relocation cases really cannot be predetermined there's no exact formula. There are no assumptions that can be made here. Instead, each relocation case is going to be considered on its own facts. Again, with the paramount concern of what is in the best interest of the child. And so all of this is to say that there is no one size fits all. If one of the cases on this topic says that if there is one certainty about relocation cases, it's that there is no certainty. So this uncertainty makes it very important to consult with an attorney if you have any questions about your situation. All right, next slide. Another question that we get sometimes is what happens if a custodial parent relocates with a child without the other parent's permission and without the court's permission? First, it is important to distinguish, to kind of separate this scenario from the scenarios that we've been discussing just now, where there is permission. In this situation where there is no permission, there are additional considerations and risks that should be considered. The reason for these additional considerations and risks is that when a parent moves a child without first having permission, there is a risk that the other parent could go to family court and ask that the parent who moved be ordered to return the child. And in addition, the court can take into consideration additional factors that don't necessarily apply where there was permission. For example, in deciding whether to obligate a parent to return a child to New York, the court can consider the fact that the parent who moved helped themselves to the move without first getting permission. In other words, it could consider that the moving parent engaged in a sort of bad act, potentially. The court can also take into consideration how much time has passed since the child was moved without the permission of the other parent. And this is important because in general, the more time that has passed since the child was moved, the less likely generally it is that a court will order the child to return because that child may have started to settle into that new location. For example, perhaps they registered for school, maybe they found new medical providers, etc. And so for this reason, if you are a parent who's with a child whose other parent has moved the child without permission, you generally want to take action quickly and not let too much time pass. Time is of the essence. These risks and the other reasons that we've mentioned, that I've mentioned here today, are why we encourage people to talk to a lawyer and to get advice about what to do in their situation, either before they make a move or if you're on the other side and your child has been moved without your permission. Okay, next slide. You may be wondering how a parent files for permission to relocate. And so you can see here, if a custodial parent wants to move with the child and there is no custody order yet, that parent can file what's called an initial custody petition in the family court. And in that petition, they can specifically ask to relocate. If there is already an existing custody order between the two parents, then the parent that wants to move can file what's called a modification petition, which is a specific form that is used when a parent wants to ask a court to modify or change an existing order. Okay, the next slide spells out, this slide here just spells out what are the different types of petitions that I just mentioned. Again, there is an initial petition for a new custody case. There's the modification petition if there's already an existing custody order. And finally, one that I didn't mention before is called a violation petition. And this petition, it can be used by a person, by a parent, if they want to allege to the court that the other parent has violated an existing order. All right, another point that we want to quickly highlight is that a parent in a custody case can request a court-appointed lawyer. The court has the authority to appoint one at no cost, so long as the requesting parent meets certain income eligibility requirements. And with that, I will pass it on to Molly, who will discuss the concepts of jurisdiction and where a case can be brought regarding either custody or the relocation issues that I've discussed.
Thank you so much, Joel. So before we talk about jurisdiction and where to file, we want to see how much you already know about jurisdiction. So we have a poll. What does jurisdiction mean? A, I have no idea. B, jurisdiction means the court's authority to make decisions in a case. C, jurisdiction means the courtroom. Or D, jurisdiction means the process for selecting a jury. Give you all just a second. Okay, and if we can have the results. All right, 97% of you, a court's authority to make decisions in a case. Yes, it's exactly what it means. Jurisdiction really means having control over something, and for the court to have jurisdiction, it means that the court has the power to make a decision about your case. And generally, the court has jurisdiction or the power to make a decision about a case when there is some sort of relationship to your case. So, for example, let's say that a child, Alice, lives in California with their mom, Betty, and Alice's father lives in Florida. In this situation, New York has no relationship to this case. No one lives in New York, and we don't have any other information about the child in New York. So a New York court would not have jurisdiction or would likely not have jurisdiction over this case. So let's talk about where to file for custody and visitation and which court has which state has jurisdiction for these types of cases. If you have never been to court before, you must generally file in the home state of your child for custody and visitation cases. And this means that you will file in the state where the child has lived for the past 6 or more months. Now, for newborns, let's say, if a child has not lived in the state for the past 6 or more months, or there's a newborn, you could file where they have previously lived or have lived the longest most recently. And the reason for the home state rule is so that the court has relevant information regarding the child or any other information related to school, any additional caretakers they may have, their medical information, and any other relevant information to what is going on in the child's life. But there's something that's called emergency jurisdiction that's an exception to this home state rule. Now, a court can take jurisdiction, meaning they can make a decision about a case, even if the child has not lived in the state for the required 6 months. But this can happen in only certain circumstances, like if the child is in danger or if there's a domestic violence situation, for example. Now, if there is an existing custody or visitation order, then generally you would have to go back to the same court that entered that original order. Then what could happen is that that court may speak with the other court that might have jurisdiction or authority and decide which court should hear that case. Now, when you file a petition, the court holds jurisdiction at the time that you file your petition, and this is referred to as jurisdiction attaching at the time of filing. This can get really complicated, so we're going to use some examples to help us better understand what all of this means. So let's use Olivia and James as an example to further understand jurisdiction. Olivia lives in Michigan with her son. James lives in Connecticut. He files for custody in Connecticut. The court declines or dismisses where you think James could file. Now remember, for a court to have jurisdiction, you have to file where the child has lived for the past 6 or more months, that home state rule. Where do you think that James can file for custody? Yes, I see someone say Michigan. Exactly. James must file in Michigan, or most likely has to file in Michigan, where their child lives. Now, let's talk about Pat and John. Pat and John have lived in New York with their 2 children for the past 5 years, but unfortunately, there's an ongoing domestic violence in their relationship. But last week, Pat took the children to New Jersey, where her family live, to escape John. Which state has jurisdiction? Well, because of the home state rule, New York, because the children have lived there for the past 6 or more months. But because of emergency jurisdiction, New Jersey may also have jurisdiction or that authority. And again, emergency jurisdiction is when a court can take jurisdiction or make a decision about a case, even if the child has not lived in that state for the required 6 months. But again, this can only happen in certain circumstances like a domestic violence situation. So we put together a timeline to really visualize how this may look. So on June 20th, today, Pat moves to New Jersey. June 21st, tomorrow, John files a petition for custody in New York. And jurisdiction is set at this time in New York because of that home state rule. The children have lived in New York for over 6 months, but also because John filed in New York on that day. So jurisdiction attaches on June 21st. But their first court date for custody in New York is over 6 months later on January 3rd. New York may still have jurisdiction, even though the children have been living in New Jersey that entire time, because jurisdiction attached on June 21st, the date that John filed a petition for custody. Now, we want you to know that this does not automatically mean that New York will keep jurisdiction, that authority. They may end up giving up their authority to hear the case if, for example, Pat were to file for emergency jurisdiction in New Jersey. But there are many factors that can affect which court will ultimately hear or decide a court case. So now that you've determined which state is the appropriate to file in, how do you determine where within the state you file? This is known as venue, and venue is the specific court that you want to file in. It's generally looking at the specific facts of the case to determine which specific court to file in, but can also be determined based on where you or your child lives. So, generally speaking, for these cases, this is where you would file. For custody, visitation, and guardianship cases, you can file where the child lives. Now, you can file in the county where either parent lives, but venue is generally appropriate where the child resides, and specifically the county where the child lives and resides, because that's more likely where the facts of the case are. And then child support and parentage cases, you can file in the county where either parent or the child live. So let's use another example to help us understand venue, and we're going to use Xavier and Ben to help us understand. Xavier and Ben have one son, Oliver, and Oliver lives with Ben in the Bronx, while Xavier lives in Queens. Ben wants to file a petition for custody. Because all three of them live in New York State, New York has jurisdiction or the power and authority to hear the case. But which family court in New York would Ben file in for custody? Probably in the Bronx. The courts will likely look to see where the majority of the evidence is. For example, if Oliver's doctors, school, and teachers are all in the Bronx, the courts will likely say that the Bronx Family Court is the more appropriate venue or place to hear that case. This can get really complicated, like I mentioned. So when it comes down to it, jurisdiction really means which state do you file in, and venue, you're looking at which county to file in. But ultimately, if you have any questions about where you should file your specific case, you should speak with a lawyer. But we wanted to provide you with some overarching guidelines on jurisdiction, venue, and relocation. So, now we have some time for questions from all of you. And again, feel free to put your questions in that Q&A feature below. Ebony, do we have any questions already in there or that popped in through the chat?
Yes, we did have one question come in through the chat. How do you prove that the other parent has not been involved in the child's life?
It's a really good question. Joel, do you want to take that? You want me to take it?
Yeah, I mean, that is a very good question because it kind of goes into how do you prove a negative, prove that something didn't happen, right?
Yeah.
And so one of the ways, the court can take evidence through different ways. And one of the ways that it can take in evidence is through the testimony of a parent. And so if the parent that the child has been living with testifies and that testimony is under oath during the trial in the case. The trials in family court are called fact-finding hearings. And if they testify that the child has never seen or been involved with the other parent and the other parent hasn't been involved, that would be one way of establishing that. There may also be documentary proof, but that would depend on the circumstances.
So,
Thank you, Joel. We had another question come in as well. What if the non-custodial parent wants to move? Are they entitled to the same type of visits that they have in the home state, or do they forfeit by electing to move, meaning that their time may be decreased based upon their own choice?
this is a really good question as well. You guys are posing great questions to us today. It can really depend on the circumstances, and I hate saying it depends, but every single case is different and can hinge on one specific factor. Like Joel was mentioning throughout, it's going to hinge on what's in the best interest of the child. But the court generally starts with this presumption that it's in a child's best interests to have a relationship, that visitation time with both parents. So it's possible, but maybe is what I can say. The court's going to look at what's in the best interest of the child, starting with that presumption, that belief that it's in the child's best interest to have a relationship with both parents.
Thank you, Molly. No other questions have come in
Absolutely.
yet.
All right. Well, we will give you all just another minute to finish typing any last questions, but we wanted to just say thank you so much. Before we go, we wanted to give everyone a reminder of how to get in touch with us. And whether you have a follow-up question from today's presentation, you need some support or assistance with your family court case, or you just want to learn more about what we do, you can reach out to our helpline by phone, live chat, or email. Again, the number for our helpline is 212-343-1122, and our website is familylegalcare, all one word, .org, O-R-G. And please also follow us on social media at Family Legal Care. You can find out more about upcoming events that we're hosting. And then finally, we'd love to hear from you and get feedback on today's webinar. And as an incentive for completing our feedback form, we'll send you copies of the slides from today's presentation. The feedback form is listed here and also is going to be linked in the chat. We'll also send emails to everyone who attended. And so that's it. Thank you again, everyone, and we hope to see you all again soon.
Before we go, Molly, we did just get
Yeah,
one question.
awesome.
So if
Absolutely.
the parent is not involved in the child's life, does the other parent still have to go to court and prove that before relocating?
Joel, you want to take this one?
Yeah, that's one of those situations where generally speaking, if um, it can depend. How old is the child? If the child is only a few months, but the parent has never been involved, then there might be a more nuanced answer to that question. But if it's been several years and the other parent has just never been involved at all, then you may not need permission to relocate in that situation.
Thanks.
But just to highlight again, it is important that each case be discussed in, based on its own specific situation. So just kind of that caveat there.
Exactly. I've seen two very similar cases turn out differently because of just one factor that may not seem the biggest factor, but that ended up being what decided the case. So it's really important to speak with an attorney or even reach out to us to speak to our helpline or be connected with one of our staff attorneys, and if you're eligible, to talk through what that factor might be. All right. Thank you all. If there's no other questions, thank you for joining us. And again, please, we'd love your feedback. Fill out the link and we'll be following up with you through email.
Thank you, everyone.
Here, everyone.